At this time, I would like to introduce Mr. Dave Duff from the firm of Duff, Lyon & Freeman to review the Attorney General opinion issued on January 4th, 2022.
Thank you, Madam Chair. Good evening, board members, and a belated Happy New Year to you. Again, my name is Dave Duff, and I'm with the firm of Duff, Freeman, Lyon in Columbia, and we've served as counsel to this district and the board for many, many years. I've been asked to discuss with you, as the chair has indicated, the recent opinion by the South Carolina Attorney General's office, which I think was issued on January the 4th, addressing that section of the Freedom of Information Act that provides that a member of a public body can request that information be added, be included in or added to or referred to in the minutes of the public body. And I'd like to begin by saying something, and I don't mean this in any way as a general criticism of the AG's office, and certainly not of this particular AG opinion, because as you'll hear in a minute, I basically agree with the January 4 opinion. But we frequently hear the refrain, mainly from attorneys who are not in the AG's office or who are working in one of the other governmental entities, that the Attorney General's opinion is one man's opinion about an issue that relates to South Carolina law. And if you've looked at the letter, the January 4 letter, you will see that the opinion was written by an Assistant Attorney General, Matthew Houck, and was approved by Bob Cook, who's been in charge of the opinion section for many, many years. And as I said, I think this is a very good opinion and one that I basically agree with. I have one little caveat that I would like to address, but I'll just start by quoting to you the very conclusion of the opinion on page 6. And I quote, "It is this office's opinion that FOIA, happens to be section 30-4-90, subpart A4, which is the section in question dealing with additions to the minutes, does not permit a public body to preempt a member of the body from including information in the written minutes of its public meetings by majority vote or through adoption of policy. However, these minutes are public records from which a public body may exempt enumerated categories of information from disclosure. Additionally, certain information within a public document is required to be closed to the public. The information which may be exempt from disclosure or is otherwise required to be closed to the public can be redacted or separated prior to disclosing the rest of the document." And I think this is, as I said a moment ago, a well-reasoned opinion regarding this particular section of FOIA. It recognizes, in effect, that a board majority cannot preempt or veto a request by in this case, a board member to include something in the minutes of the board simply because the majority thinks that it's not appropriate or they just simply want to oppose the request. The AG says you can't do that. The statute and the plain language of the statute, this particular section, says that a member of the public body can request that information or material be added to the minutes. And there's no specific qualification to that much of what FOIA says. But as the AG opinion also says, that the minutes are public records from which the body may exempt certain enumerated categories of information from what the member asks be appended to the minutes. And that whatever the material or matter is that the board member is requesting be attached to the minutes, that the information that may be subject to an exemption can be redacted or separated from the document prior to the document being included or added to the minutes. And I agree with that. I think that's an acceptable and an accurate interpretation of this particular section of the FOIA statute. The one area that I think the Assistant Attorney General, Mr. Houck, could have been a little clearer about is that I believe the statute envisions that what a member might ask be included in the minutes of that particular meeting relate in some way to what was discussed at the meeting, something that was on the agenda of the meeting or that came up in proper discussion regarding a matter that had to be discussed or potentially voted on by the body. So, and an example would be, it's kind of a silly example, but suppose a board member or a member of the public body said, I'd like to include in our minutes the Manhattan phone book. That would be silly, unless the board was talking about getting in touch with people who live in Manhattan, and then adding the Manhattan phone book might be relevant to the topics that were discussed at the meeting. So I do think that the material or information that is requested to be added to the minutes should and would relate to something that came up in the board's discussion of that meeting, at that meeting, a topic that the board had to take action on that may have resulted in some discussion where the particular matter was discussed by the board. So I think that the AG opinion really doesn't specifically address that because I think it's implicit. It's implicit in any fair reading of that statutory section and didn't really need to be explicitly reiterated in the AG opinion. But again, I think it is a sound opinion. In general, courts give due deference to AG opinions that are well-reasoned. Their courts aren't obligated to agree with the Attorney General in a written opinion, but they do give a certain amount of deference to an AG opinion, particularly when it is well-reasoned, as this one is. So I think that the board now has the board asked for this opinion, and with its rendering, you now have some fairly clear guidance on how you can deal with requests by a member of the board to include information or material to the meeting minutes. Can I answer any questions that board members may have?
Yes, sir. This is Jada. So originally, you had redacted portions of the minutes. Are you still advising to redact those portions of the minutes?
Ms. Garris, you're speaking of the minutes that will be the subject of the next item on the agenda?
That's correct.
Yes, I was asked to, almost in anticipation of what the Attorney General has now said on January 4, I was asked to give my opinion about what matters might be subject to an exemption under one of the statutory exemptions, and I gave that opinion, and I suggested what I thought was the language or the information on the document in question that could be properly and lawfully redacted in the document when it gets included in the minutes. So yes, I did give my opinion about what could be properly and lawfully redacted.
Thank you. And under what exemption are you properly and lawfully suggesting that we redact that document?
I'm sorry, repeat that?
Under what exemption are you advising that we properly and lawfully redact that document?
I believe most clearly the redaction is provided for in what I call the personal privacy exemption under section 30-4-40 subpart A2.
Okay.
In my view, certain portions of the document in question would be subject to the personal privacy exemption.
Thank you. So if you invoke the personal privacy exemption, you must first determine whether the information requested is personal and whether disclosure would constitute an unreasonable invasion of personal privacy. And then second, the public body must determine whether to disclose the information. The information has been requested, and I'm reading from the Attorney General's opinion here, what I just read, and it has been determined not to be personal or not to constitute an unreasonable invasion of personal privacy because this same document has been released to a member of the public without redactions. So how would you claim an exemption for personal privacy for information that has already been released to a member of the public?
Well, I accept what you've said as being accurate. I believe it is that this very same document pursuant to a FOIA request by a citizen was provided to the citizen in response to the FOIA request in an unredacted form. I personally think that that was an oversight, but more fundamentally, I would make a distinction between a document that was provided to a FOIA requester that may have been unredacted and what is now attached or requested to be attached to the public records of the board's meeting minutes. So I think there's a distinction there, and it is still my opinion that what is, assuming the board acts to include the document in question in the minutes, I think it's minutes of a prior meeting. It is still my view that the particular information that I have suggested and recommended be redacted is still a valid action to take in its including it in its redacted form.
Mr. Duff, can I ask, so if the document that was released with the information that should have been redacted, that was an error.
In my view, that was an error.
It was an error committed by staff in response to a FOIA request. The existence of that error doesn't compel us as the public body to compound that error by including the unredacted version in the minutes. Is that correct?
That is correct. That is my opinion, yes.
I mean, because I feel like it's still incumbent on the board to do the right thing and to comply with the legal exemptions in order to protect personal privacy.
Agree.
Okay, so looking at personal privacy exemptions, we'll go over those in a second, but with that same argument, say that first document was an oversight, it was an error, which it could have been, but the information that you're trying to redact still shouldn't be redacted. But how would you claim an exemption if the same information is already included in these same minutes in another document? And there are actually quotes from the meeting in that document that have also been redacted.
You've lost me. Is this the very same document that was produced to the requester?
Well, the requester has all of the documents, yes. So during this meeting, I requested 2 emails be included in the minutes. And one was included and one was not. And the one that was not has been heavily redacted by you. But some of the items you've redacted from that email, they are already included in the minutes in the other email because they reference each other.
you're asking me some specifics that I don't have immediately in front of me. I'm not clear on what the other document that may have been included is. I may have seen it in the past, but as I stand here this evening, I can't address that any further. I can only address what I have addressed, which is that the additional document that you wish to be included, and it is your request, is it not, Ms. Garris?
It is.
All right, the additional document that you now be requested be included through amendment to, I believe it's the July 2021 minutes. As I've already said, I have suggested the language that should be redacted under the FOIA exemption for personal privacy. And the reason I am is because what I suggest to be redacted deals with the performance of an employee in a critical way before the board has even taken up the matter of that particular employee's performance. So it kind of falls generally in the category or area of personnel and performance by an employee. And what I've redacted is the critical negative assessment of that employee's performance, again, before the board has even taken that matter up. And I believe that, therefore, this is information of a personal nature, the public disclosure of which would constitute an unreasonable invasion of privacy. And that's my legal opinion about what I recommended be redacted.
Thank you. I'm still saying I don't understand how you could redact information that's in one document and there's another document in the minutes that has some of that same information that's been redacted. And I disagree that this is the negative performance of an employee, evaluation of an employee. That is not what this was intended. That's what y'all made this to be. This is a board member requesting information, and y'all put this to the AG as that's what you wanted it to be, and then asked, hey, can state law trump our policies that says a board member shouldn't be giving a negative evaluation of an employee? But that wasn't what this was. So there's a long list.
I understand your position. I respectfully don't agree with it.
Well, I don't agree that you can redact information from a document that's already been released and is in the same minutes. And also, going back to the personal privacy exemption, there are a list of things that fall under personal privacy. That's social security numbers, driver's license, checking account, savings account numbers, credit card, debit card, personal identification numbers, digital signatures, dates of birth, current or former names, current or former addresses.
Ms. Garris, I have a
Yes.
question, and this is a sincere question. The pieces of information that are currently redacted, what do you hope to gain by having those pieces of information included in our minutes in perpetuity? What is your objective? Because I've not been clear on that from the beginning.
Okay, so 20 years from now, when people look back and they wonder how we're at where we're at now, that we still haven't accommodated growth, but we keep building schools, they'll be able to see and follow along and say, oh, okay, Jada had concerns about allowing a builder to assign a dollar amount to a project without any supporting documents, and then 2 years later, the project ended up costing 3 times what it was originally supposed to cost.
And I'm just asking, can those questions be asked, like you just did? You put Jada into that and nobody else. Could those questions not be asked without casting negative motives and negative actions on personnel?
Yes, they could, and this isn't negative. That's the whole problem. Y'all said it was negative, but it's not. So if you'd put it in the minutes, then everybody else could see this is not a negative evaluation of an employee. As a matter of fact, I quote this employee in here, and that whole paragraph that they said in a board meeting, it's been redacted, word for word. I quoted what they said in a board meeting, and the whole paragraph has been redacted. Makes no sense to me.
Other board members, does anyone have any thoughts or? discussion of this? Or a recommendation for a way forward? As we, does anyone have any more questions for Mr. Duff? Okay, all right, thank you, Mr. Duff.
Thank you.
Okay. All right, we're moving on to item 6.3, which is, okay, during the October 19th, 2021 board meeting, and I believe that was November, actually. Was it October? October, we tabled the motion to amend the minutes of the July 20th, 2021 board meeting. Do I hear a motion to take from the table the motion to amend the minutes of the July 20, 2021 board meeting?
Madam Chair, I move that the board take from the table the motion to amend the minutes of the July 20, 2021 board meeting.
Thank you, Dr. Guyton. Do I have a second?
Second.
Thank you, Ms. Garris. All right, now is any discussion about removing that item from the table? All right, hearing none, all in favor, please say aye.
Aye.
Anyone opposed? All right, and the motion carries. Okay. Ms. Garris, do you happen to have your original motion?
I do.
All right, would you mind repeating, where you were going back to the original motion from the October meeting, would you mind repeating your motion?
Yes. Per policy BCBH that states minutes will include supporting materials where such information serves to clarify matters on which action is considered or taken, and because the approved minutes reflect that Jada Garris's email to the board was included, I make a motion to amend the minutes of the July 20th, 2021 board meeting to include Jada Garris's email to the board as requested during the July 20th, 2021 meeting.
Thank you. All right, so we do have the motion back on the table. And so at this point in time, what we have to consider is the redacted version of the email, to add that to the minutes. Is there any discussion about that?
So my motion is to include the entire email. So I guess if someone wants to include the redacted email, they would have to make a motion to.
All right, is there any conversation about the email and?
Right. So just clarifying, because I heard you saying part of it was already included. So I was trying to pull it up real quick on my computer, but so it's an email chain. And what you're saying is the bottom half of that chain is already in the minutes, but the rest isn't. And part of the bottom half that's in the other has already been redacted or hasn't been redacted, is what you're saying?
No, so there was two emails. There was one to an employee, and then there was one to the board as a follow-up saying, here's what I learned from this employee. And I quoted some things from my email with the employee. And some of the things I've quoted, that first email made it in the minutes, the one between myself and the employee. The email between myself and the board has been redacted and has not made it in the minutes. It was mistakenly omitted.
Okay.
Madam Chair, if I might, in terms of parliamentary procedure, I think that if it is the desire of a board member the proper way under parliamentary procedure to would be to amend Ms. Garris's motion to include the redacted version of the document. And that would be done by a motion to amend Ms. Garris's motion, which would be voted on first. And then there would be a follow-up vote to include the document.
Okay, thank you for the clarification, Mr. Duff.
So I guess this kind of highlights more of a process that we seem to have uncovered, and certainly we appreciate the Attorney General giving us the opinion as we requested. I understand both sides of this argument, quite frankly. I understand a desire for a board member that feels something should be added to the minutes that is of sustenance and importance to be included, I, in my position, did not understand what that could include. You know, for example, the Manhattan phone book. I didn't know if there was ever a point at which the board in its entirety would sit in judgment over that request. And I think we have determined that that is in fact not the case, that a board member can request ultimately most anything, obviously the more germane, the better, to be added to the minutes. I would have the question of, once a redaction occurs, it almost appears that this argument becomes circular. Because you have the proposed amendment, then at some point, somebody has to request a redaction, for which I don't think we have a process for, quite frankly. Then somebody has to redact it, and then that redaction has to come back to us, and then again, we're brought back to the same question of, are we sitting in judgment of this redaction? I think for me, a lot of it comes down to liability, and you know, as a board, do we incur liability as a part of our vote that would come for that, particularly of the, I believe they said 19 exceptions or whatever it may be. So I think there is some inherent liability that we have to address. I will say I'm not in favor of speaking about any employee outside of Dr. Little, because in my frank opinion, Dr. Little is the board's employee. Everybody else is Dr. Little's employee. That's how this has worked, at least in my opinion, for quite some time. So it would become a challenge for me to include any other employee of the district as a part of a request. But again, I think this kind of highlights the difficulty we have with the process. Maybe less about the content, more about the process by which we arrive. So that would be the only thing I would offer.
Thank you. I would like to follow up as well, Kyle. Once, you know, as Jay Bender said, the horses have already been let out the barn. Once you've released a document to the public, you can't go back and redact it. It's done. It's public information, and if it was an error, then it was an error. I don't believe it. Well, I'm glad it was an error, because had they tried to redact that from the public document to begin with, I think that would have been a violation of FOIA. However, I'm not even sure why it wasn't disclosed to the Attorney General that the document in question has already been released as a public document. No one ever told him that. So that's my take on it. The horses are already at the barn.
But I do believe that there is a callback provision somewhere, but what we're dealing with right now is what we've got. We've got a staff error, and does the board take on that error, or does the board do what is right by what we have in front of us, is my question. No, sir, no, ma'am. No, ma'am. All right, I'm going to ask, is there a motion to amend Ms. Garris's motion to consider the redacted version of the email and include it in the minutes?
Well, the redacted version is what's in our packet, so I would suggest that the redacted version is what's on the table, not the original one.
All right. And that's what I would consider, but that was, I was trying to accommodate Ms. Garris's interpretation.
I mean, I made my motion. I guess we're waiting for an amendment to my motion.
Yes.
And
Because she offered the motion and has explained the spirit of her motion, I will honor that. So is there a motion to amend her motion to consider the redacted version of the email?
And otherwise, we're voting on the unredacted version.
Right, that's correct.
just quick question though. originally when this was requested and was supposed to be put in the minutes, but was inadvertently left out? Was it the redacted version that was supposed to be put in there, or the original version?
That was the original version that was accidentally omitted from the minutes. It wasn't until this drug on, and over the course of several months, I tried to get the email put in the minutes, and I guess someone then took a look at it and decided to have an attorney redact certain portions of the email. So that's why this is still going on from July.
From July.
So currently on the table is Jada's motion to put the email in the original way it was supposed to be put in before it was left out.
Yes.
Okay,
And,
just to
and,
clarify.
I've served on a lot of public bodies, I've reported to public bodies, and again, generally minutes reflect the presentations and the discussion at hand. We need to think carefully about adding multiple emails and documents that happened outside the meeting.
And Dr. Powers, I agree with what you're saying, and I heard what Dr. Guyton said about our employee being Dr. Little, and that's who we should talk about, and then everyone else is his employee. I think where I'm getting stuck is that this should have been included, and it was left out.
Well, and I'll clarify on that, because at the time, we were trying to figure out how to navigate this, because this is a request that we've never had before. And
We've never included emails in minutes.
And I'll tell you, my full intention was to put the email in and then figure it out. Do we go back and amend it and redact it? And when we voted that night, I thought it was included. For 3 days, I thought that email was a part of what we included. I found out on that Thursday afternoon that it was not part of that. And that's when we started the process of figuring out, all right, we don't have to go back and fix it. Maybe we can fix it before we put it in. And so and I'm being completely transparent about how this
Right,
happened.
and you've shared
I mean, because it really was, because I read this law as saying, we have no choice, we have to put it in. She requested it, we've got to comply. But we do have other laws and other requirements on us as a public body that I think we have to consider, like the privacy and the reputation of our employees. And so I was committed to trying to do the right thing by putting the email in, but also do the right thing by trying to fix maybe some things and I wasn't sure how we were going to do that. And so then when we realized when I found out that it had not been included, that's when we started the ball rolling of trying to figure out, well, what can we do to make sure that what we put in the minutes is truly appropriate for us to enshrine forever in the records of this body. So that's how we've gotten to this point. I think we have an obligation to staff members that, and, to me, it could, there might be staff out there that's listening to this, and if for some reason there's ever an email about them and a board member says something critical about them, I say something critical about one of my kids' teachers, and then that gets somebody requests to put that in the minutes. Well, I don't think that that's appropriate, because that teacher doesn't work for me. And so, and that's a hypothetical, but I just think we need to think about everything we do sets a precedent for the future. And so I'm just trying to be very, very cautious that we are within the law taking great care with our employees, or with Dr. Little's employees.
So to follow up to that, it's very clear why the statute is written the way it is. This is an example of why the statute allows board members to put anything in the minutes. I want to include something in the minutes, but other members of the board may not want me to. My right to do this would disappear if not for the statute. And that's why the Attorney General is clear when he says, if a public body finds an exemption applies and elects not to close, well, that's the wrong one, separate and exempt. But he says, May a public body impose reasonable limitations, y'all asked this, on a member's ability to request inclusions or additions to the minutes based on FOIA and/or policy? And he says the language is clear. You know, South Carolina Supreme Court has held that when the meaning of a statute is clear on its face, then the rules of statutory interpretation are not needed. The words of the statute must be given their plain and ordinary meaning without resorting to subtle or forced construction to limit or expand the statute's operation. So he's saying you might not like what I want to put in the minutes. You might think that the Manhattan phone book is silly, but at the end of the day, I have that right. And unless you can claim a personal privacy exemption, which does not exist here, under FOIA, then you can't keep something out of the minutes. I mean, you could vote to keep it out of the minutes, but in my opinion, I'm not an attorney, but in my opinion, that would be a violation of FOIA.
So Jada, I'm just asking you this question because I think where I'm struggling with this is that it should have been included. We should be months and months past this. It shouldn't have even been a blip on the radar, but here we are. And a lot of things sometimes that we do sets precedents for the future. So I think the one area that I'm just a little cautious about is where do we draw the line? So if Mr. Oswald wants to include something about a senior staff member or emails, communications regarding something going on with them, and we say no, he can say, but we put Jada's in there. Do you see what I'm saying? So like,
You could argue that, and then you could get another attorney general's opinion. They're going to tell you the same thing, that unless there's an exemption under FOIA that allows certain information to be redacted, then as a board member, you don't have that right to withhold that that board member's request to put something in the minutes. I mean, I don't know if y'all have looked at other board members' minutes in other districts, but in a neighboring district, I mean, they have a stamp. They have so many things that go in their minutes every month. I mean, they have board members that come back and handwrite notes about, here's what I hate that the way I said something in the meeting was interpreted this way. Here's how I meant for it to be interpreted. So it's enshrined forever. Or, I mean, one of them.
oh, well, I think that's great because that
Right.
would be like me saying, I think what I said was interpreted incorrectly.
Right. There's a page out of the dictionary in there, and there's tons of emails between staff and board in there. Yeah.
And you're right, it should have been a blip on the screen. This is one email, we've been talking about it since June. And at the end of the day, not a single thing that we have said in the last 40 minutes does anything for students or staff. Not a single thing. Nothing. And so, is there a motion to amend Jada's original motion? All right, then we will vote on, Jada, would you please state your motion one more time?
Yes. Per policy BCBH that states minutes will include supporting materials where such information serves to clarify matters on which action is considered or taken, and because the approved minutes reflect that Jada Garris's email to the board was included, I make a motion to amend the minutes of the July 20th, 2021 board meeting to include Jada Garris's email to the board as requested during the July 20th, 2021 meeting.
Thank you, Ms. Garris. And at the time, Dr. Guyton was the second. And so I think we've had a lot of discussion on this. Is there any more? No? All right. And as a reminder, all in favor of including the email in the minutes from the July 20th meeting, please say aye.
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 Anyone opposed?
Opposed?
I
And the-
oppose.
All right. No, it's 3-2. The motion carries.